Mr. Keithley, I put your client in your room. On the record in the matter of the people of the state of Michigan versus Heather Derrick. File number is 22-00194 FY. Council appearance, please.
Good morning, Your Honor. Andrea Lee, appearing on behalf of the people.
Good morning, Your Honor. Jackie Moss, appearing on behalf of my client, Heather Derrick, who is standing to my right.
How are you both?
Good, thank you.
Students will take them set for preliminary examination. My understanding is there's going to be a plea. You have a plea sheet with you?
Yes, I do, Your Honor.
Okay, and on vice rights, you can approach. Thank you. Okay, I have here a plea sheet. It says that the defendant's going to plead guilty to an added count 2 of false pretenses, $200 to $1,000, contrary to Michigan Compiled Law 750.21838, which is a misdemeanor. Maximum penalty is 1 year and/or $2,000, and that the people move to dismiss count 1. Is that what you recall your offer to be, ma'am?
Yes.
You want to accept that offer?
Yes.
There's a killable agreement, which is a sentencing agreement between you and the prosecutor of no upfront jail. That's also part of your agreement, ma'am?
Yes.
Have an advice of rights. Well, actually, let me swear you in. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you. I have a rights of plea information sheet here with today's date on it, ma'am. Is that your signature at the bottom?
Yes, it is.
Did you read this document?
Yes, I did.
You understand the rights listed here?
I do.
Do you have any questions about those rights?
No.
You understand that you have the right to proceed to trial in this matter?
Yes.
You understand that you have the right to have a jury trial?
Yes.
At the time of your jury trial, ma'am, you have the right to question or cross-examine any of the witnesses that the prosecution intended to call. You have the right to call your own witnesses or present any evidence you believe would further a defense to the charge. You have the right to remain silent at trial, not have silence be used to prove or implicate your guilt. And you also have the right to be presumed innocent until each element of the charge is proven beyond a reasonable doubt. If you accept this plea offer, you're giving up each of those rights. You understand that?
Yes.
Okay, is anybody making any promises or threats to you to get you to waive those rights today?
No.
Okay. Are you currently on probation or parole?
No.
You understand that a guilty plea could result in a conviction that may need to be reported to your current job?
Yes.
You also understand that a guilty plea could result in a conviction that may affect any immigration status you may be trying to seek. Okay, you still want to waive your rights, understanding that?
Yes, I do.
And are you pleading guilty because you believe you are guilty?
Yes.
Okay. Lastly, because there's a killer agreement, which is an agreement that I'm not a party to, if at the time of your sentencing, I'm going to deviate from your agreement and sentence you to jail time, I would then grant you the opportunity to withdraw your plea, okay? Okay, do you have any questions about that? Okay. As to the added count two of false pretenses, $2,000 to $1,000, how do you plead, ma'am?
Guilty.
On a factual basis?
Yes, Your Honor. Ms. Derrick, were you before Judge McCormick on December 3rd for a PPO proceeding? As a part of that PPO proceeding, was there evidence that you presented to Judge McCormick?
Yes.
That evidence that you presented to Judge McCormick, was that evidence of a false and misleading nature?
Yes, it was.
At the time that you presented that evidence to Judge McCormick, were you sworn under oath?
Yes, I was.
And as a part of that oath, you were to testify truthfully, correct?
Correct.
And by providing the evidence you did, that was against the oath that you took?
Yes.
And this all occurred in the 30th Circuit Court in Lansing, Michigan, Ingham County?
Yes.
Is Your Honor satisfied that all of the factual requirements have been satisfied?
Any questions from the prosecution?
Yes, Your Honor. Ms. Derrick, that proceeding was a continuation of a proceeding that had started on October 22nd of 2021. Is that correct?
Correct.
And this was the type of hearing, it was a hearing for a personal protection order. Is that also correct?
Correct.
And that was in a case of Paige Green versus yourself, Ms. Heather Derrick, correct?
Correct.
Okay. And this was in front of Judge McCormick, but that was in the family court. Is that correct?
Correct.
Okay, Your Honor, the people are satisfied as to a factual basis for the underlying count, original count of perjury, and we would ask that you accept that for purposes of the plea agreement.
Thank you. The court is satisfied with the factual basis. I will accept the plea if I appeal it voluntarily and intelligently. This matter will be set for sentencing. Sentencing is going to be June 17, 2022 at 8:30 in the morning. If that time works for your attorney.
That was June 17th, Your Honor?
Correct, it's a Friday.
Yes, that will work.
Okay, and that could be via Zoom if all parties consent.
No objection from the people.
No objection.
Okay, so if you have the ability to log into Zoom, we could do it that way. You're welcome to come in person otherwise. Okay, do you have any questions, ma'am?
I do not.
You need to meet with probation when you leave here. They're going to provide the court with a pre-sentence report. So you have to have an interview by them. You can go down there when you leave here today because you do have to meet with them within 48 hours, but you're already here because you have to meet in person. It makes sense for you to go right now. They'll give you a questionnaire to complete and they'll schedule your pre-sentence interview based on that questionnaire. And that interview will likely be via Zoom as well, okay?
Okay.
And so they'll provide the court with some information to consider before your sentencing date. Do you have any questions?
And that's downstairs.
They're right on the 5th floor. Correct. Thank you. No problem. Do you have any questions? Okay, additional matters for the record.
Nothing from the people.
Nothing from me, Your Honor.
Thank you. You're all set, ma'am.
Thank you, Your Honor. Have a good weekend.
Thank you. Have a good one.
Here we go.
Mr. Keithley. We have someone in the courtroom and then it's representing McBride. You're representing Ms. McBride as well?
I am, Your Honor.
Okay, very good. And who's in the jail?
Say,
Rashad Trice.
Okay, what are we doing with Trice?
It's gonna be a plea, Your Honor.
We have the record in the matter of the people of the state of Michigan versus Rashad Malik Trice. File number is 21-03410 FT. Council appearance.
Morning, Your Honor. Andrea Lacy, appearing on behalf of the people, and Assistant Public Defender Sarah Donnelly on behalf of the defendant Rashad Trice, who is appearing by Zoom from the Lansing Police Department.
Thank you. Today was the date that was set for preliminary examination. My understanding is that there will be a plea. That's the only place to offer on the record.
Yes, Your Honor. The offer for Mr. Trice is to plead to an attempted count 1 of fleeing and eluding home fourth degree, as well as the original count 2 assault and battery, both misdemeanors.
Okay, so you're adding account 3 of fleeing and eluding, attempted fleeing and eluding?
Yes, Your Honor.
He's gonna plead guilty to the count 2 of assault and battery.
Correct.
Ms. Donnelly.
Yes, Your Honor. At this time, Mr. Trice would like to accept that offer.
Okay, is that correct, Mr. Trice?
Yes.
Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, thank you, sir. You can put your hand down. Okay, Mr. Trice, you have the right to proceed to a trial in these matters, and you have the right to have a jury trial. At the time of your trial, sir, you have the right to be represented by counsel. You have the right to question or cross-examine any other witnesses that the people intend to bring. You have the right to call your own witnesses or present evidence that you believe would further any defense to the charges. You have the right to remain silent at trial and not have silence be used to implicate or prove your guilt. And you also have the right to be presumed innocent and to have each element of the charge against you proven beyond a reasonable doubt. In order to plead guilty, sir, you have to give up those rights today. You understand that?
Yes.
You want to give up each of those rights?
Yes.
Okay, and you're sure about that?
Yes.
Anybody made any promises to you to get you to give up those rights?
No.
Anybody threatening you to get you to give up those rights?
No.
Are you pleading guilty because you believe you are guilty?
Yes.
Are you currently on probation or parole?
Yes.
Which one?
Probation.
Okay, out of which court, sir?
Livingston County.
You understand that a guilty plea could potentially have an impact on your probation status. It could cause you to have a violation.
Yes.
Okay, and you still understanding that want to waive your right to plead guilty today?
Yes, but I got a question real quick.
Absolutely.
I'm on probation at Livingston County Jail. They gave me a county year with a 2-year probation. I'm not sure, do my probation start afterwards or?
Yeah,
I'm
Your
not sure
Honor,
how-
he's not on probation yet. He's still serving the sentence and then he'll be
Okay.
released on probation.
Sounds good. Okay, very good. So was that your question or more of a statement, sir?
Yes, that was more like a statement.
Okay, sounds good. Okay, so then you understand that a guilty plea to this charge or these charges may need to be reported to your current or your future job?
Yes,
Okay, and also could have an impact on any immigration statuses that you may be seeking. You understand that?
yes,
Okay, with those understandings, you want to plead guilty, sir?
yes,
As to the added count 3 of attempted fleeing and eluding, how do you plead?
guilty,
And as to count 2 of assault or assault and battery, how do you plead?
guilty.
On a factual basis.
Your Honor, just hold on a second. I have a.
Attempted fleeing and eluding.
Okay, cool. All right.
Mhm.
That's okay. Thank you, Your Honor. I'm ready to proceed. All right, Mr. Trice,
Yes,
on May 30th of 2021, were you traveling along I-96 near Dietz Road in Ingham County?
yes, I was.
And while you were traveling westbound on I-96, did you stop and punch or hit David Mulholland?
Yes,
All right, and then did you continue on and then on northbound 127, were you traveling on northbound 127 in the city of Lansing, Ingham County, Michigan?
yes, I was.
And then at that time, were you given a signal to being the driver of a motor vehicle, you were given a signal directing you to pull over on North 127, correct?
Yes,
And that was by Michigan State Trooper Andrew Golden, correct?
yes, that's correct.
All right, and you believe he was acting in his lawful duties, correct?
Yes,
All right, and having directed you to stop your vehicle, you did attempt to willfully fail to obey that direction, correct? By fleeing and eluding?
yes,
And you were apprehended the next day in Clinton County, correct?
yes, that's correct.
All right, I have no further questions.
Any questions for you, Ms. Lacy?
No, Your Honor, I believe that would satisfy all of the factual basis for both charges.
The court is satisfied with the factual basis. Mr. Trice, I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be June 17, 2022 at 8:30 in the morning. Prior to sentencing, you're going to have to meet with probation so they can provide the court with a pre-sentence report and recommendation. How long are you going to be in custody at Livingston County?
Right now, Your Honor, his out date is in November, but that he doesn't have trustee status yet. He needs to, he has to resolve this case before he can get to the dorms.
Okay. We'll note that here on the file. Do you have any questions today, sir?
No, I don't.
Any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
Thank you. You're all set, Mr. Trice.
Thank
you. Okay, Mr. Keithley, did you want to proceed with Ms. McBride first?
Yes, Your Honor.
Mr. Bigelow. Okay, we're on the record in the matter of the people of the state of Michigan versus Megan McBride, file number 22-00033 FY, council appearance.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Megan McBride, who is present via Zoom.
You said it was a date that was set for a sentencing. I do have a pre-sentence report and recommendation. Did you get a copy of that?
I did, Your Honor.
Okay, this date, we originally had a date of February 11, 2022. It was crossed out, and a date of March 25th, 22 was added as the date that this was prepared. Is there any reason for us to make any updates, corrections, or deletions?
No, Your Honor. Well, I can address this during allocution if the court would prefer. As the court may remember, there was an issue as to whether Ms. McBride got a substance abuse assessment done in relation to this case. For some reason, Ms. McBride was referred to Cristo Ray as opposed to having had it done in-house. And I don't know why that was done. At the time of her original sentencing date, my understanding is that the probation department had not received the evaluation from Cristo Ray. After speaking with Ms. McBride about it, she followed through on the assessment with Cristo Ray, and there's some sort of a breakdown in communication between Cristo Ray and the probation department that caused that delay.
Okay, I'm not sure what the issue is as to this assessment or the report regarding the assessment. There's some other, I guess, issues the probation officer noted in the report, but I'll let you address those during your allocution.
Thank you, Your Honor. I think there's some confusion by Ms. Duhosky in terms of what happened as far as the plea proceeding here that comes to light during the report. Ms. Duhosky indicates that she believes that Ms. McBride was being dishonest in terms of her stating that she doesn't use methamphetamine because she did enter a plea to use of methamphetamine. As the court may remember, that was an artificial plea. She laid a factual basis to possession of methamphetamine with a reduced charge of use being entered on the record. Of course, Ms. Duhosky, in terms of authoring the report, would not have had access to a transcript of the plea and wouldn't be able to tell them. I don't know, and I think that is the ultimate source of the confusion on Ms. Duhosky's part there. As to Ms. McBride's statements that she doesn't use methamphetamine, without going too deep into the confidential communications between myself and Ms. McBride, she has, at least to me, always maintained that she doesn't use methamphetamine. She's never admitted to use of methamphetamine. To me, I was not surprised to hear her deny use of methamphetamine. And again, she wasn't actually charged with use of methamphetamine. And in this case, there was no evidence of actual use. That was a charge reached as part of the plea agreement, and she laid a factual basis as to the possession charge in this matter. And as to statements that feeling that she was on some level forced into or anything as far as the plea. I think that is a miscommunication or at least a misunderstanding. I know that in terms of the criminal process, that can be very daunting to people, and that it can feel, when discussing the potential ramifications of a conviction and and the possible benefits of a plea, it can feel to a certain extent, I don't want to say coercive, but it can feel like that's your only way out. As to the other parts of the recommendation and to the recommendation itself, I believe the recommendation is otherwise appropriate here. Ms. McBride is an individual I think will do well on probation. She maintains she doesn't believe she has a problem with substance use. And again, I personally, in terms of my interactions with Ms. McBride, I have not seen any evidence of an issue with substances. Again, her plea was an artificial plea as to use on facts for a possession. And she's denied use in terms of her interactions with me throughout the course of my representation. Your Honor, we would just simply be asking that the court adopt the recommendation here and place her on a term of probation with 7411 status. Thank you, Your Honor.
Okay, Ms. McBride, how are you?
I'm doing okay.
Okay. The report that I have from probation indicates that you stated to the probation officer that you do not use or is not a user of methamphetamine, but you pled guilty essentially because your attorney advised you to. Is that how you feel?
As referred to like what he said, yeah, he
I don't want to get into what he told you because that's confidential communications. I just asked a very direct question as to if you pled guilty because he told you to versus when I asked you, are you pleading guilty because you believe you are guilty?
I believe I'm guilty. Yes, ma'am.
Oh, that's all I wanted to make sure. Because I don't want to misinterpret what the report is stating. So at this point, I don't know what the substance abuse assessment states. I can only go by your word, which is that you don't have a substance abuse problem. You don't have any prior criminal history, so you would be eligible for a term of probation with the special status. So I suppose if, in fact, we're mistaken about your needs as it relates to any substance abuse issue, we'll find out during probation. And so at this point, I'm going to place you on a term of 12 months probation. I'm not going to order you to complete any outpatient at this time because I don't have any information that would indicate otherwise. But I am going to order that you would be responsible to complete any treatment as recommended by probation. I would imagine they're going to follow up and get that information from Crystal Ray. I'm also, although I'm placing you on a 12-month term, due to the nature of this plea that I don't have a lot of information before me to rely on, I am going to set it for a review at 6 months, okay?
Okay.
Because if I find that you didn't have an issue that we did, then I don't need you to sit on probation for 12 months, okay?
Okay.
I'm gonna grant your request for 7411 status.
Thank you.
While on probation, you're not to use, purchase, or possess any alcohol, marijuana, or controlled substance. You understand that?
Yes.
Any drug that you have must have a valid prescription written to you, okay?
Okay.
You are going to be required to submit to random PBTs and or your analysis. You need to pay the fees associated with that, okay?
Okay.
You're not to be at any bars or nightclubs while on probation. And I think the information shared is that you're not currently employed. Is that still accurate?
Yes, ma'am.
Okay, are you looking for employment?
Yes, ma'am.
going to order that you obtain employment and provide proof of that employment to your probation officer, okay?
Okay.
While on probation, there's a $30 per month oversight fee that you're responsible for. Do you have any questions at this time about the requirements of probation?
No.
Okay, I see you didn't complete high school. I'm gonna order that seems like you're relatively close. Complete high school while on probation as well, okay?
Complete high school as in go
You
to,
need to get a GED or a high school diploma is completion.
okay,
And so as to fines and costs, I'm going to waive any discretionary fines and costs. However, there is a $75 crime victim rights fee that you would be responsible for, as well as a $50 state minimum cost that you're responsible for. If you did do a complete 12 months of probation, it would cost $360 in oversight fees.
is that without the $30 a month or is that total?
That is, no, that's the $30 a month times 12 months. So that's if you end up doing a full 12 months. It's a
Okay.
total of $485, and you would be making monthly payments on that, okay?
Okay,
Okay, and so I have here an advice of rights for probation. It says you have been sentenced to a term of probation in a 54A district court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense was asserted of guilty but mentally ill, you may be eligible for early discharge from probation. You have the following rights. You have the right to request an early discharge from probation once you have completed half the original term ordered by the judge. You may request an early discharge from probation after meeting the following conditions. You have completed all required probation programming and you have not violated probation in the last 3 months. If a hearing is scheduled, you have the right to retain or hire an attorney to represent you, but you do not have the right to court-appointed counsel for that hearing. Lastly, you may make your request for early discharge by completing a notice regarding eligibility for early discharge from probation, which is available on the court's website. Do you have any questions about those rights, ma'am?
no,
Any additional matters for the record?
No, Your Honor, thank you.
Okay, you're all set, ma'am.
thank you very much.
You're welcome.
Am I good?
You're
Good.
good to go.
Okay.
Yes. Okay, sir. Mr. Moore, is that correct? You can come up to the table there. Write it up. We're on the record in the matter of the people of the state of Michigan versus Justin Deshaun Moore. File number is 21-03261. Council appearance, please.
Good morning, Your Honor. Keith Lee, Assistant Public Defender, appearing on behalf of Mr. Moore, who is present in the courtroom.
It was the date that was scheduled for sentencing. I do not have a pre-sentence report because I have a note here, Mr. Moore, that you failed to appear for your appointment.
Yes, that's why I talked to him earlier. I got a folder with a lot of information in there, and by me working 12, 13-hour shifts at Dakota, I'm not gonna use it as an excuse, but it is kind of hard, you know, once I get out of work, I'll be super tired. And I also help out with my son's football team. We about to get ready to get back and doing that. So I'm not trying to use that as an excuse, but it is a lot that I'm doing right now. And I was wondering if I can have another chance.
That's exactly what I'm gonna do, because with all that you got going on, you can't do that if you're sitting in jail because you didn't go have this appointment. And I think the appointment can be virtual.
Okay.
So you just need to log in and do it so that we can move on.
Okay.
You need to go down to probation when you leave here today and get a new date. I'm gonna reset your, I'm gonna give you a new referral, and I'm gonna reset your sentencing. We can do June 17th. June 17th at 8:30, okay, sir? Do you have any questions? Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set. We'll get you the referral in just a moment. Do you have a matter?
Yes, two. One, Miss Clark,
Oh, both yours are in custody, correct?
yes.
Okay.
And then Mr. Benavidez, was he brought over from the Clinton County Jail?
He's supposed to be.
He's downstairs? Yep. Right. I think that's just gonna need a new date and then,
Benavidez will,
yes.
and then, okay.
That was, today's the PE, but it was treated as a PCC.
Oh, that's
Split
right.
it over. I still don't have the report, but I looked at my notes. I should have it by the end of the day.
So then, you think that they can just put him on the polygraph? Yeah. And then, Mr. Petrovich just walked, oh, his guy had a bench warrant anyways. Petrovich.
And she's double checking on witnesses for Ms. Clark, but
Sounds good.
assuming nothing's changed, that may very well be the balance.
Okay.
We might be able to put her in the room and deal with it that way if we need on the record for that.
Thank you.
I'm still looking for Adam. Sorry.
I think so. Sir. Blackman here. And Clark is in jail. No, Blackman is the defendant. She's here. I think she.
Oh, did I say?
You did.
Submitted a filing.
Wait, where's the Drika back?
Oh, yeah.
I haven't seen a Drika. I haven't seen a Drika today. Did you check it?
Not with me,
Who's the Drika? If I don't see a Drika, I'm not signing it.
Mr. Carter, but I know he's down in the jail speaking. with-
I know we had her on a city day. I know she looks like.
I know. She better be here. Do you know if Miss Blackman is here, Miss Lacy? Miss Lacy, do you know if Miss Blackman, Adrika Blackman is here?
She's not. I just talked to Mr. Carter. He's been calling her, but she's not here.
Well, no knowledge.
So I didn't know. So.
Dang.
She just decided that.
Okay, well, I'm gonna give this back to you for now.
Okay.
I hate when my clients do that. Like a trial set or anything?
Nothing, no trial, I really don't wanna go. I don't wanna take it to certain.
Right.
It's not, I know.
You can go up to the screen there, Mr. Benavidez. Up you go all the way up, all the way up.
You going?
I might have dialed in the wrong code.
Oh, that's the right one.
Is it?
Are we up? Right.
So,
Are we up here right now?
we are not now.
Talk about Blackman one time.
Sounds good. On the record in the matter, the people of the state of Michigan versus San Benavidez, file number 22-00848 FY. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Benavidez, who appears over Polycom.
Thank you. How are you, Mr. Benavidez?
Good morning, Your Honor.
Okay, how are you?
Could be doing better, Your Honor. Still incarcerated. Plain County has me
Okay.
here still since March 11th due to these false allegations.
Okay, well, we'll let your attorney address any concerns about your bonds, okay?
Yes, Your Honor.
Okay, well, today was the date that was originally scheduled for your preliminary examination. However, we do have a couple of issues. First, you were supposed to be written over from the Clinton County Jail last week for a probable cause conference before the court. And for some reason unknown to me, that writ did not make its way to Clinton County. So you were not present last week for your probable cause conference. So I had intended to use today as a probable cause conference date, and then I'm finding good cause to adjourn the 21-day timeline and setting your exam for another date. But I do think there's still a issue of outstanding discovery. Is that correct?
That is correct. And I had my office follow up this week on that issue, received communication. Here's late yesterday, early this morning, that the issue was our parents made it to their office, but did not make it to their file. And so the discovery being sent to us was not triggered. My belief that's being corrected, and I should have that by the end of the day. As soon as I get it, I will make sure Mr. Benavidez gets a copy of it so that he can review it as well.
Okay, sounds good. Okay, so at this time, the court is going to find good cause to waive the 21 days, as I previously indicated. I'm going to give you a new probable cause conference date and then a new exam date, okay, sir? Mr. Benavidez, did you hear me?
Yes, Your Honor, I had a question on that.
On the probable cause conference and exam?
Yes, Your Honor.
Sure, what's your question?
I just wanted to know if, like, is there any way, I mean, because I don't know, it's just, I'm being held, you know,
This about
under.
bond again?
Yes, Your Honor.
With,
Okay,
no, it's
yeah,
not.
I'll allow your attorney to address bond after we get through this other stuff, okay?
But yes, Your Honor.
Okay.
For his probable cause, we can do May 13th at 8:30.
May 13th at 8:30 will be your new probable cause conference date.
And then the exam will be at May 20th.
Your exam
At
will be May 20th at 9 o'clock in the morning, okay, sir?
Yes, Your Honor.
Any additional matters before we proceed to the bond motion?
Not from the people.
You can proceed with your bond motion.
So actually, Your Honor, I think the issue that Mr. Benavidez has is that Clinton County is holding him pending a probation violation. I mean, Mr. Benavidez can correct me if I'm wrong, but my understanding is that he does not actually have a bond in Clinton County.
I think that's accurate.
I would ask, is the May 13th, May 20th, are those the earliest date the court has? Just because he's going to be held until both of these things can be resolved. And my understanding from talking with the family this morning is that the Clinton County Circuit Court is not going to take any action on the violation until the criminal case resolves itself.
What are we, the 5th and the 6th?
So we might be.
Do you need to have another PCC? Because we don't have to if you don't want to.
I don't believe we need another PCC. If
Okay.
I believe we're just going to proceed to exam based on the conversations I've had at this point.
Sounds good. Scratch the PCC and see if we can move this exam up.
Yes, we're on the record. People have no objection to that.
Thank you.
I shook my head, but I know that doesn't show on a record.
Trying to see if we can. That's the earliest, because we have the 2 code exams.
There's 2.
Yeah, these two.
Oh,
And then.
on what day?
The next day.
The 5th? Are you in the 5th? No, will you go to the 5th? Do you put on the PCC day?
Okay.
Are you available on the 5th? It's our PCC day.
Depends on what time.
8:30 or 9.
I could do either of those times.
Okay. That was the 5th, right?
Yes.
Okay, we'll do the exam on May 5th at 9 a.m. Okay, so you're clear, Mr. Benavidez. You're being held regardless because of your issue in Clinton County, okay, sir?
So, Your Honor, you're saying the issue with Clinton County is because of these allegations, right?
That is, well, that's what I'm being told, is that they're holding you for a bond violation, and the bond violation can't be addressed until they figure out what's going on with this case.
So they can still hold me until I can still be held
Correct.
until this case is resolved.
That is correct.
Isn't there a 45-day ruling on that? Your
On your
Honor,
bond? Or,
with, with Clayton County, holding me, because I understand.
you're gonna have to talk to Clinton County about that, sir. This is Ingham County, so I don't have any control of their hold for you, okay?
Right, I just,
And so you have an attorney in that matter?
yeah, I do, Your Honor.
Okay, you probably want to have that attorney try to address your bond in that court. Your
And,
bond here, it doesn't sound, we're not holding you without a bond.
Right, so the $15,000 bond, is that still in
There's a
place?
15,000, 10%.
And that's still in place, Your Honor?
Correct.
Okay, I also wanted to say, I know, before this, Your Honor, before this all happened, I was letting the courts know that I was still gonna be detained. And this was a couple weeks ago. So I don't know how that I miss, that prelim, that probable cause conference when I
No,
needed
that
to head.
wasn't, it wasn't anything that you did. That was a court error, sir. The
Okay.
clerk's office, when you came over to be arraigned, it was noted in the file that you were being held by Clinton County, and so that they need to prepare a writ. And it does not sound like a writ was ever actually sent to Clinton County, is what came to my attention.
Okay, I didn't understand, because being behind those walls is kind of different from being behind your guys' walls. It's just a whole misunderstanding, a jam with everything. And, I'm just lost behind everything, with everything going on.
I'm gonna come down in a moment, Mr. Benavidez, and speak to you and kind of explain things in more detail, okay?
Yep.
All right,
Any additional matters for the record?
Not from the people.
not from the defense.
Okay, you're all set for now, Mr. Benavidez.
Can I have one more question? Is it able to ask that question, Your Honor?
Sure, I don't know what the question is, so I always get scared when there's a question. I'm gonna advise you that you have the right to remain silent, and anything you say can be used against you. So to the extent that you're gonna ask me something that might be used against you, you might want to run it past your attorney, but if it has to do with anything else, feel free.
Well, because, with the other, I know you have nothing to do with the other county, but I just feel that, is there any way, and is there any possible way if somebody could, write this judge, because she's saying I'm a menace to society, and then we got over here that I'm not a menace to society.
Okay,
Mr. Benavidez, I will talk with your attorney in Clinton County. I know who that is.
right. That's the
So I
best.
can reach out to him. and
That's
try
the
to
best
work
way
on
to
that.
handle it. Your attorney has to contact over there. I can't call another judge and tell them to change their bond for
Yes.
you. Okay?
Yes, Your Honor. Yes, Your Honor.
All right, I'll be down in just a moment, Mr. Benavidez.
Okay, you're all set,
Yes.
sir.
All right.
Okay. So what do I- Blackman? Okay, is she here?
Carter.
Okay, we're on the record in the matter of the people of the state of Michigan versus Adriki of Blackman, file number 22-00826. Council appearance.
Good morning, Honor Andrea Lee, appearing on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Ms. Blackman, who is not present.
Thank you. Today was the date that was set for preliminary examination. It was scheduled for 8:30. It's currently 9:49 and Ms. Blackman is not present and we wanted to address something.
Yes, Your Honor. Your Honor, once I was informed that Ms. Blackman had not shown up today, I did make phone calls. I did talk, I called her phone number that was given to me on file. A woman answered that phone and indicated to me that my client was in a bad accident either yesterday or the day before, and she is in Cedar Creek Hospital, which is a mental health clinic in St. John's, Michigan. As far as being able to verify that, obviously, because of disclosure laws and all that, I'm not.
Okay. How do you want to proceed?
At this time, I'd ask that bond warrant be issued for Ms. Blackman. I believe she was in court earlier this week or last week And when I called the victim yesterday, I noticed after talking to a female for the second time, that it happened to be the same phone number as listed on the police report that I have for the defendant. So I don't know if I spoke to Ms. Blackman or a different female, but somebody did answer the phone number that listed as her phone number in my police report, and did tell me, oh, I'll definitely have him call you tomorrow or before tomorrow, when I told her what it was about. So
I would indicate that she is married to a female, so that could have easily been her spouse.
I think the concern though, was you said it was the victim's number was the same number as the defendant.
that's what it's listed in as a police report. I didn't realize it at first because I don't check the defendant's phone numbers when I call my victims, but I thought it was weird that for the second time it was a female answering saying she had
Okay.
this person called me.
I guess I misinterpreted that. As far as, it's my understanding, talking with my client, that the victim is staying with his grandmother, so whatever phone number was called, I guess we'd have to see if she called the same number as I did. But I have a phone number for her herself. So if she had talking to the victim's grandmother, that could have been very well the scenario.
Okay, I'm not sure. What I will do though is that I'll hold the bench warrant for 48 hours, business hours, that is, to see if you can get any further information or clarification as to where your client is. She did appear for a court date earlier this week, I believe. Or was that last week?
I'm not sure if it was this Tuesday or last Tuesday, but it was a Tuesday.
Yeah, she did appear earlier. But I can't say that she has never missed court before in the past, because she has. So we're gonna need some verification on why she did not appear today on a felony matter before we can move forward. But I've noted here that she's possibly at the Cedar Creek Mental Facility. If they can provide verification to you that that's where she is, so you can provide that to the board.
Thank you.
Any additional matters for the record?
Not on this. Thank you.
Thank you. Okay, we're all set on that one. And so you said you had one more, was it Ball?
I have all.
Jesse Page, your attorney, you applied that.
Mr. Page? Did they deny him an attorney? Or do we just not know?
Says applied on April 3rd.
Okay, you're Mr. Page?
Yes, I am. Good morning, Your Honor. I can-
1 second, sir. My note says that you had an attorney at your exam. Where's she?
Probable cause. This
Yeah,
is
your
the exam
PCC.
today.
Yeah, correct.
Okay.
Where is she?
So the probable cause, she was there, I was there.
Where was
There was
she
an
today?
issue with the court that day.
No, where is she?
She's not, because she thinks it's probable cause today. You never had a probable cause hearing.
No,
It was
you, no. Let me call the
She's
case.
not here.
We're on the record in the matter of the people of the state of Michigan versus Jesse Jerome Page. File number is 22-00906. FY, counsel, can I have your appearance?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Thank you. And sir, you state your name for the record?
Jesse Jerome Page.
Thank you. Mr. Page, today's the date that's set for your preliminary examination. We held your probable cause conference on April 14th, at which time you were represented by your mother. Is that correct?
Correct.
What's your mother's name?
Ivona Radonovich.
Correct. She was told that she needed to file a proper appearance because we had not received the appearance. Where is she today?
She can be here in
Well,
a minute, but
she was supposed to be here. She needs to be here in the next 10 minutes. Where is she?
she can be here. until next year.
Okay.
All right.
Can you step out and call her so she can get here for your
Okay.
exam?
Yeah.
Thank you. Okay, Ball, is he in custody?
Yeah. He is, Your Honor. There's an issue with Paul that we'll need to address on the record.
Okay, are we gonna go bring, we can go bring him up. Do you need to handle something before he gets here? Okay. His attorney? Okay. Yes, please. On the record in the matter, the people of the state of Michigan versus William Ball, call number 21-02692. FY council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
May it please the court, David B. Carter Jr. on behalf of Mr. William Ball, who apparently is here in lockup but not present.
I think you say was the date that was set to continue the exam that began on February 18, 2022. The prosecution needed to address something on the record.
Your Honor, the victim in the case, Ms. DeBoer, is here today. She informed me that Mr. Ball has been threatening her from the jail, initially to make her not appear, but then changed his mind and decided she needed to appear and threatened her to have her here today. He called her as recently as last night, should be evidenced in the jail call system, and apparently sent people to her home. Now, because of that, I have a concern with her being called today. And frankly, because this was just created last night by the defendant, the people need to investigate that matter. And it should be relatively quickly, given the fact that I see 2 calls from his account from last night when this is supposed to have taken place. But those calls, based on the information given to me by the victim, dictate what she should say and not say.
Okay. Mr.
Your Honor, I was informed that allegedly my client had contacted the victim. When I talked to the prosecutor earlier today, I went down there and met with my client. He denies that. He denies that he sent anybody to his house. He denies that he called her and threatened her.
Okay. So your concerns with her testifying today, I mean, we have her here today.
No,
and
my concerns
There
are,
could be a concern that if she doesn't testify today, she may not come back.
I'm aware, Your Honor, my concerns are effectively we could be supporting perjury. Because she's indicated to me she's terrified of him, terrified of what will happen to her if she doesn't testify in the way that he wants it to.
Okay, so how do you want to proceed then?
Your Honor, I'd ask for a week adjournment so I can listen to these calls. I'm not in favor of another adjournment in this matter, but given the fact that it was specified they happened last night, there's something that people could have done to have found those.
Okay, so your witness is what you're saying, afraid to now testify because of?
She's afraid to testify in a way that goes against what Mr. Ball wishes her to testify to.
And that's going to change with an adjournment?
I believe that with those calls, I could then impeach the witness in regards to those bias and the motive of what she's testifying to, if it's as explicit as she informed me.
Okay, so your plan is to get the nature of the calls to use it to impeach whatever she states on the record?
Correct, Your Honor.
Okay, why can't we elicit her testimony now while she's here and then call her back?
The concern is, much like the court said earlier, then she wouldn't be back here. We'd be taking what would effectively amount to perjury without the opportunity to cross-examine and impeach on that with that witness.
Mr.
I can appreciate the prosecutor's argument, but I think it's doesn't hold water. She's here. If his fear is that she may not show up next week, well then, if we don't have her testify today, that's the same argument. She may not show up next week. It's,
I understand you have an argument. I get it. I feel the same way Mr. Carter does as it relates to this. She doesn't come next week. Or it actually won't be next week because I'm not holding court next week. But if she doesn't come in the next following weeks because the fear has set in or otherwise, you're still going to be in the same position you are in today, which is you won't have enough probable cause to bind over. So I think we need to proceed while she's here. I will order her back here for any further elicitation of your direct after you've had an opportunity to get that information. Then you can obviously feel free to question her on the record as to any conversations she testified that she had or told you that she had with the defendant while under this court order from not to have direct or indirect communication. The other thing is we're constantly getting these allegations that there's been direct or indirect communication. And the prosecution should be looking into that, and I appreciate that they're doing that, but I'm gonna need them to also follow up on that and issue charges if that's the issue. And maybe start sending a message so we can stop having these issues.
Understood, Your Honor.
So with that being said, let's go get Mr. Ball because I want to get as much information as possible while we have the victim.
Thank you, Your Honor.
No problem. Okay, we're on the record in the matter of the people of the state of Michigan versus William Ball, file number 21-02692 FY. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
May it please the court, David D. Carter Jr. on behalf of Mr. Ball, who is present in that council table.
Thank you. How are you today, Mr. Ball? Okay, today was the day to continue your examination. We are set to continue that examination. But it does not sound like it's going to conclude today due to some new discovery that the prosecution is working on. Any matters that we should address before we call the next witness?
Nothing that hasn't already been stated on the record.
Okay, anything from the defense?
No, Your Honor.
You can call your witness.
People call Alyssa DeVore. Nope, not that.
Okay, Remy, you can put your stuff on the chair there. It's not a lot of space, so. If you want to put it, sit on the chair. Nope, right there. So that you can have more space in the witness stand. Then I'm gonna have you face me. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yeah. Okay, thank you. You can have a seat there, ma'am. And so a couple of rules. You need to, there's a microphone in front of you. I have a court reporter who's directly behind you. Her job is to take down everything stated in the courtroom. So she has to be able to hear you, which means your responses must be verbal. She can't record head nods and shakes, okay? You have to also keep your voice up. It sounds like your voice is kind of light, okay? And then if you need to remove your mask during your testimony, you can do that. Your responsibles can't be uhs and ahas. They used to be yes or no's, okay? Then also, if there's an objection by either of the attorneys, you're gonna stop giving any response. There, I'll make a ruling on that objection, and then I will advise you as to whether or not you can give that answer or not, okay? Okay, please state your first and your last name and spell them both.
Alyssa DeBoer, ALLISSADEVOER.
You can proceed.
Thank you, Your Honor. Morning, Mr. DeVore.
Good morning.
Do you know William Ball?
Yes, I do.
And how do you know him?
He's a ex-boyfriend.
Do you see him in the courtroom today?
Yes.
Could you please describe where he's located, maybe something he's wearing that differentiates him from the other people? If the record reflects, she is pointed at the defendant.
Any objections, identification?
No objection.
Identification is noted.
On September 24th of 2021, did you have contact with police?
I really don't remember the date, but yes.
Somewhere around that time seems accurate.
So yes.
Yes.
Was that at 2124 Rio Road? And had you been with Mr. Ball that day?
Yes.
When you spoke with the officers, did you have red marks on your face and neck?
Not on my face, no.
On your neck?
Yes, on my neck, but I told them not to take a picture of my face because they were insinuating that there was marks on my face and I was.
So it was just to the neck area.
That's a yes.
Thank you, Your Honor. Could you please tell the court what caused those marks on your neck?
I'd rather not.
I'm gonna have to ask you to be honest, ma'am. Could you please tell the
You're,
court?
you're under oath, ma'am.
He got an argument and Will quickly put his hands on my neck, but he like always needed it.
Was this inside the house?
Yeah,
Were the two of you alone there, or was there somebody else there?
there were a few people.
When you spoke with officers, was one of your windows broken?
Yeah,
And do you know what had caused that?
a pumpkin.
I couldn't hear.
A pumpkin?
Okay.
So it's safe to say a pumpkin had been thrown through the window.
Yeah.
Do you know who threw it?
No.
Did officers come out there more than one time that night?
Yeah.
You spoke with them both times?
Yeah.
Did Will put his hands on your neck before the first call or in between the two calls?
The first one?
Did you tell police that the first time they came out there?
Yeah.
Ma'am, isn't it true that the first time police went out there, you told them everything was fine, and it wasn't until the second time that you told them about it?
Yeah. But the second time he did not come over was not him.
Now, why did you not tell police the first time they went out there about him putting his hands on your neck, but told them the second time?
I told them the second time because I know that at the end of the day, Will's not gonna do anything to kill me or hurt me. He cares about me. And I know somebody else came to my house the second time and I don't know who that was. And I don't know what their intentions were. So I asked the police to stay. They told me they weren't gonna stay. So I tried to say anything I could to make them stay.
So isn't it true that you told the police officers that when he had his hands on your neck, he thought you were going to die?
I might have said that, but I know that he wouldn't let me down.
When the officers came out there the first time, was Will still at the residence?
Yeah,
And where was he located?
in my bedroom.
I got just one moment, Your Honor.
No problem.
Mr. Board, apart from him putting his hands on your neck, did he touch you in any other way, such as a punch?
No,
Isn't it true that you told officers he had punched you in the face?
no,
Did you try and leave that residence during this incident?
No.
Isn't it true you told officers you tried to run away and he physically stopped you?
no,
Isn't it true that you told the officers first time you went out there, you couldn't tell them what happened because Mr. Ball had a gun pointed at you?
Your Honor, I'm gonna have to start objecting on leading. witness.
Would you want to respond to the objection?
Your Honor, I believe this witness is hostile. It does not wish to testify accurately about what happened that day. She even said that she'd prefer not to say what happened.
I'm going to overrule the objection. I do agree that we may be dealing with a hostile witness. I want to also remind the witness that you're under oath and there's a penalty of perjury. So what that means is if there's evidence to determine that you are lying while under oath, you can be charged criminally. Do you understand that?
yes,
Okay, you can proceed with the question.
I'll repeat the question. Mr. Board, isn't it true that you told officers that night that the reason you didn't tell them when it first came out that Mr. Ball had attacked you was because he had a gun pointed at you from the back room?
no, I can look in.
Ma'am, not at this time yet. Please answer questions. Isn't it true that you told the officers that when he had his hands around your neck, he had a difficult time breathing and began to black out?
If I did tell them that, that's not true.
And you said the reason that you lied to the officers is because you wanted them there for your safety.
Yeah,
Isn't it true that the officers asked if you wanted to leave to a more secure area and you refused?
yeah. Also, let me take that back, 'cause I don't know if they ever asked me that, but I never wanted to leave my home and I was never held at my home under my watch.
Mr. Bork, you've been contacted by Mr. Ball while he's been incarcerated.
Yeah.
Have you been contacted by people on his behalf while you've been incarcerated?
Yeah,
And did the nature of those contacts involve your testimony at court today?
no, they really just wanted to see if I was coming.
They weren't about making sure that you were going to be here?
No.
At any point were they designed to have you not come to court?
No,
How frequently has he contacted you, or have you been contacted on his behalf?
it's been a long time. There's been two first.
And I know it's hard to have a frame of reference. I've just been asked to estimate, but is it every week, every day? What kind of volume of calls are we talking about?
Well, I'm pretty sure that the jail has blocked, him from being able to call me, so whenever that blacklist are put in place, I have not talked to him.
So you've talked to other people for him?
Yeah, I've actually also made contact myself to another friend that I have in the jail and made mental remand to let him know that I am.
Okay. Thank you very much. Your Honor, at this time, the people have no further questions for Mr. Bourne.
Okay, I just have a brief question about the address. You said that happened at 2124 Rio Road. Is that in the city of Lansing, ma'am?
Yeah.
Is that in Ingham County?
Yeah.
Okay, cross examine.
Thank you. Ms. DeBoer, my name is David Carter. I'm going to ask you a series of questions. If there's a question you don't understand, please let me know and I'll try to rephrase that. Fair enough?
Yeah.
I'm going to try to go through the same pattern as a prosecutor, not to throw you off, just to give you an idea of how I'm going to do my questioning, okay?
Okay.
Now, you indicated that you remember having police contact on September 24th of 2021. You couldn't give the exact date, but somewhere around there, correct?
Correct.
And that was dealing with an argument with Mr. Ball, correct?
Yeah.
Was he your boyfriend at the time?
Yeah.
Can you tell me what that argument was about?
I can. It was, I wasn't home at the time, but I called them and it seemed like there was a lot of people in the background and like some of them were females and like I got upset about that and I told them I didn't want them at the house when I got home and they were there. And so I started an argument when I got home.
So if I'm correct, you had contacted him on the phone early.
Yeah,
You heard a lot of people in the background and some was female,
yeah,
and that upset you.
yeah.
Did you believe that it was maybe he was entertaining other females besides you?
Maybe for a second, maybe, yeah.
Okay, a little jealousy, little upsetness.
Yeah,
So where were you when you made that phone call?
on my way home.
From where?
Oh,
Okay. And how long did it take you to get home from hanging up the phone call and getting?
Maybe 25 minutes.
All right. Had you been drinking or using other controlled substance during that day?
I took Xanax that day.
Xanax? Does that impair your memory? Does that cause you to be paranoid? Does that cause you to do anything?
Yeah.
Okay.
It does.
And had you been on a heavy dose of Xanax?
I can't even tell you really what dose I took that day.
Okay. Were you in your right mind during this time?
I don't think either of us were.
All right. Had you been using any other drugs besides Xanax?
No.
Any street drugs, alcohol?
I'm not a drinker.
Okay. And when you indicated that you arrived home, there was several people there. Do you know who those several people were?
I know who a couple of them were.
And who were those people?
A woman named Shelly. I think maybe someone who was related to Shelly and Mitchell Ramirez.
Who is Mitch?
Mitchell was friends between me and Will.
Did you tell the police these other people were there?
They didn't ask.
Okay. What caused you to call the police? Or was it you who called the police?
I did not call the police.
Okay, so the police just showed up.
What happened to make the police come as me and him were arguing outside?
So you believe that maybe a neighbor or somebody called the police?
I think either a neighbor or somebody was at the house because something got stolen in the midst of this, and we think that somebody either called the police to steal what they did out of the house, or they called because we were arguing. I don't know.
Isn't it true that during this argument that you actually threw a planted pot at Mr.
Yeah.
Ball? And that was before Mr. Ball ever touched you, isn't that correct?
Yes, it didn't hit him, but yes, I did.
Okay. And so it pretty much started getting physical with you throwing things at him
Yeah,
and you being upset with it.
yeah.
You indicated that he had put his hands on your neck. Is that what you said?
Yeah, but he instantly, you could see like the difference in his eyes immediately. Like he instantly let go and said, "I'm so sorry."
Okay, so it was a quick reaction type.
Yes.
Did he squeeze down at all or anything like that?
No.
You didn't start to lose consciousness or out of breath or anything like that? I think you
I
indicated that,
quickly got back up right after.
okay, and I think you indicated that the second time the police came out there, you wanted them to stay and they said they weren't, right?
Yeah,
So then you started, is it fair to say you started exaggerating things to make it
Yeah.
sound like
yes,
you really wanted them to stay there,
Yeah.
correct? Now, it wasn't because you didn't want, they, strike all that, I'm gonna start over. It wasn't because Mr. Ball was there that second time, was it? You weren't afraid of Mr. Ball, were you?
no,
You were afraid of something else, right?
yeah.
What was that fear?
I was afraid because I had called another friend over between police being there. So after the first time I called a friend over because I live in a bad area and my windows were open. I didn't feel safe. I called a mutual friend between me and him over to the house to make sure, nobody keeps in my window. I have a screen camera outside and I seen a person that couldn't be Will because the person was short, very skinny. They had a black mask. I knew something was weird about it. And they acted like they were walking past my house. But the second they got to the corner, they immediately charged at my house and broke my bedroom window that he did not break.
Okay, so from the first police contact to the second police contact, you saw through your camera system
Yeah,
an individual that that did not look like Will at all, correct?
it was not.
And you know what Will looks like, you could ID him, correct?
Yeah.
And so there was this prowler, so to speak, around your house and that made you fearful?
Yeah,
And he was by himself?
yeah,
Is that when you thought your windows were shot out?
yeah.
And it turned out that somebody had thrown something at the window,
Yeah.
correct?
Mhm.
And you don't know who that was, right?
It was that. Well, let me get this straight. At the beginning, my living room, at the first time my living room window was a pumpkin was on it. The second time, it was this second person who threw something at my window, which ended up being a pumpkin as well.
Okay,
But I didn't go outside, so I just assumed they were gunshots. I didn't think people just like threw pumpkins at my window.
all right. So the second police contact had nothing to do with Will. It was
Nothing
this
to-
prowler.
had nothing to do with it.
And was there a third contact with the police that day?
No.
Okay, so the only incident that is dealing with Will was this short argument that you guys got into,
Yes,
in which you had started physically by throwing something at him, correct?
yeah,
And then him reacting, putting his hands on you and immediately releasing, correct?
yeah.
Was Will ever keeping you inside that
Never,
house?
never,
Did he ever threaten you?
no,
Did he ever tell you that he was going to physically harm you?
No.
Did he ever have a gun?
no.
Why did you tell the police he had a gun?
Cause that's just what I assumed how the windows were. I thought they were shot out, and it took till the next day that he came back and repaired the windows himself that I went outside and realized that they were pumped.
Who has the exhibits? Did the court keep those in the file? May I approach? Ma'am, I'm gonna show you what's been, may I approach the witness here?
may.
Ma'am, I'm gonna show you what's been marked as defendant exhibit A. Is that you?
Yeah.
And do you see any marks on your face that was caused by Will?
No, no, I don't.
Okay. Is it fair to say that you were emotionally upset and you had been crying?
Very.
Do you see any red marks at all?
I see them on my face, but I don't see them on my neck.
Okay. And when you say you see them on your face, are they around your eyes?
Yeah.
Is it from crying?
Yeah.
Oh, thank you. Is this a fair, a fair picture of what you look like there that day?
That's a very bad picture.
Sure. But I mean, as far as any injuries or anything like that, correct?
I would say I do have naturally dark circles around my eyes. I don't know why my nose is red from crying.
How many times did the officers take pictures?
Twice. And the second time I told them that they could not.
I'm going to show you what's been marked as People's Exhibit 1. You see that picture?
Yeah.
You see the red marks around the cheeks?
Yeah.
Is that a fair depiction of what you look like that day?
I can't say if this is the photo that they took the second time, but when JB came over, I sat there and cried and told him about the whole thing and how scared I was. And I naturally have like these like marks around my eyes, and like this is definitely from crying and being upset and being awake and staring out my window. And I told them they could not take a picture of me because they were assuming that I was hit. And I told them I was not hit, so please don't take a picture of me and assume that.
And in that picture that I'm showing you, there's a, looks like a red smudge underneath your left eye. And it actually looks like it goes right into your hair. Do you see that?
No.
You don't see the, yes. Do you see the red smudge that goes right into your,
This looks like something on my table.
okay, on the table, I'm sorry. But it seems to be the same color, doesn't it?
Yeah.
Seems to be like the ink is just kind of flowing right off your cheek right onto the table, isn't that correct?
Objection, I believe counsel is testifying at this point about what's in that photo as opposed to having her say what she sees in
I'm
the photo.
asking her, isn't that correct? I'm asking you, doesn't that appear?
Honestly, this
I'm
looks like
gonna address the
something on my table.
objection. I guess the objection is to leading, is that what, because that's what he's doing.
And I'm allowed to lead, she's,
Yeah, I don't see any issue with the question. I'm gonna overrule the objection.
all right. After that first contact with the police, did Will ever come back to the apartment or house?
He came back the next morning and
Oh.
appeared my window.
Okay, the next morning. I have nothing further, thank you.
Okay, before we proceed with the redirect, I don't know if you want to continue with redirect now or adjourn so you can get your further discovery, and then I will call her back for redirect.
I think an adjournment would be proper, Your Honor.
Okay, so I'm going to adjourn this matter so that the prosecution can retrieve the further discovery that they need before they can proceed with the redirect. Ma'am, you are going to be ordered back here to continue your testimony at another date, okay?
Okay.
Oh, we did.
Mine is-
One
To be clear, it has been,
I think you were supposed to have Officer Slobin to
Slogan,
testify.
that's just right. We had Officer Mangrum testify last time, correct?
Right, so we're gonna give her the new date. You can still call Officer Slobin.
I do not have Officer Slogan here today.
Oh,
I was
okay.
just adjourned for the date.
Sounds good.
And I'd ask, you're gonna have them here, okay.
May 13th,
And
8:30.
I'm sorry, I just want to make an objection to the adjournment just for the.
Okay.
to create a record. We would be objecting to adjournment, Your Honor.
Okay.
This is the time set for the preliminary exam, a continued date of the preliminary exam. I understand that the prosecutor is asking for an adjournment based on some alleged phone calls that were made into the jail. I don't think that's a proper adjournment. Ask the court not to adjourn.
Okay, Mr.
For the reasons I stated prior to the testimony beginning today, I'd ask that you grant the adjournment.
Okay, well, to clarify the record, the continued adjournment or the continued discovery, I think was necessary to confirm whether or not this testimony elicited today was given in a manner consistent with being under oath truthfully and honestly, as the prosecution has reason to believe otherwise. And so due to that information, which my understanding is maybe some new discovery, the court's gonna grant the adjournment for May 13th at what time?
I think I might be in a trial. Give me 1 second.
No problem.
Yes, I'll be picking a jury in front of Judge Allen.
But we could put it on our PCC day. the week before. That was a PCC day. No, the week before, the day we do the other exam. The 5th. Yeah. Does that work for you?
On the 5th, yes, that
Works for the people.
May 5th. May
Yes.
5th. At what time? 8:30. May 5th at 8:30. Any additional matters for the record?
Not from the people, Your Honor.
No, you're right.
Okay, ma'am, we'll get you a copy of your notice to appear, okay? Okay. Thank you. We're off the record.
Thank you, Your Honor.
No, you're good. You're good to go.
No, you can go. You're all
Yeah,
set.
we're all set for the day. I believe Mr. Page is here with his attorney, Your Honor.
Okay, sounds good. Okay. Mr. Page and your attorney. Back to the table. Okay, we're on the record in the matter of the people of the state of Michigan versus Jesse Jerome Page. File number is 22-00906. Counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Your Honor, Ivana Rabin-Trerick for the defendant,
What's your P number, ma'am?
47975.
Okay, today was the date set for preliminary examination. A probable cause conference was held on April 14th. And ma'am, you appeared at that time. You had not filed an appearance, which means you can't get discovery on this matter.
Well, Jesse did not feel, Jesse's my son, by the way, okay? So I will refer to him by his first name. He did not feel that I needed to appear at that. And it was like 20 minutes prior to that conference that he let me know that I should.
I'm sorry,
So-
who's the attorney here? Are you
I'm the
representing him?
attorney. I'm the attorney, yes.
Where do you work?
I'm retired. I used to work for Department of Corrections and then I worked for Human Services.
What did you do at the Department of Corrections?
I was a litigation coordinator at Ionia Maximum, and then I was also a hearing officer in Coldwater and Jackson Prison, et cetera.
Okay, are you familiar with handling a criminal matter?
Fairly, yes, I represented him in the previous one.
Okay, so why didn't you know you needed to file an appearance, and why are you asking him if you should appear for court?
The defendant does have the right to say, no, I do not want you there.
Okay,
That's
but
what happened here, so, you know.
but you say you're appearing on his behalf. You didn't appear today, though.
No, because he again told me that he didn't need me to appear today.
But you've told the court that you were representing him.
That was the other matter that was last week.
No, this is this same case, same matter.
I just filed my appearance right now.
Okay,
I came last Friday after to file the appearance. The court was closed.
the court was not closed. We were all here last Friday.
Well, the
No,
doors
we
were locked.
were all here on the 14th. The court was closed on Friday
Right,
because it was
okay.
Good Friday.
Yes.
But you were supposed to file your appearance when you took or decided you were going to represent him. He was arraigned on the 3rd.
Yes.
He has a constitutional right. I'm sorry, he has a statutory right to have a preliminary examination within 21 days of his arraignment. And because you all can't figure out if you're representing him or not, he can't proceed with this case. I don't know what kind of games are being played here, because these are games. That's why I asked, are you familiar with handling this? Because I've never had an attorney handle a legal matter, a criminal legal matter in this manner before. Like, I've never had this happen. So you bring your appearance today and you hand it to the prosecutor.
There are no games being played here, Your Honor. I'm sure you're familiar with how personalities are in our world. One day, a person may say one thing, the next day they may say another, okay? And Jesse has had some issues with his psychological well-being, okay, in the past, because he suffers from narcolepsy. He's been prescribed Adderall, which had had a negative effect on him in the past, okay? So this is why it's kind of up and down with him. Right now, he, for example, he has not seen his children a couple of years because he threatened to kill himself in front of the kids. Ingham County front of the court has an order that he can only see his kids supervised and he's to get a psychological evaluation, which he has not done yet, okay? So this is what I'm dealing with. The behavior is up and down.
Okay, you've now filed an appearance on this case, ma'am.
Yes, this morning, because he kept calling me
Sir?
saying that case cannot proceed without an attorney.
No,
Okay.
he said that his attorney, when he got here today, he told me he had an attorney. I said, well, she needs to be here. He wanted to know if you can appear via Zoom.
Yes. I
Why would you
understand
appear via Zoom if you're representing him? Because you're supposed to be here for an exam. We can't run an exam via Zoom. Are you prepared to proceed on your exam today?
that. Yes, from what I know.
Okay, so you've gotten the discovery.
No, I had not.
I would hate to have to report this before the bar because you're trying to proceed on a felony exam and you've not requested discovery. You just told me on the record you're prepared.
Okay, again, it was yesterday even that Jesse told me.
I'm not,
He
no,
did
no,
not
no,
need
ma'am,
me.
I don't want to hear what your client told you.
Okay,
What I want to know is why did you just tell me you're ready to proceed on a felony exam and you have not looked at one piece of discovery because you haven't even requested it? Are you looking to lose your bar license?
no, I'm not looking to lose my bar license.
Okay,
This
I'm
is
gonna ask
what
you
I'm
again.
dealing with.
Are you prepared to proceed with your exam today?
I guess I'm not, and perhaps you
You
should.
guess you're not? Okay, well then we can proceed.
Perhaps you should appoint a court-appointed attorney.
That's not how this works. If you want to request, if he wants to request a court-appointed counsel, he can. Not a perhaps if I want. You just filed an appearance before the court. You told me you were ready to proceed, but then you told me these are not games.
I'm going by what Jesse told me occurred.
I'm going to advise you that this is going to be reported to the state bar, okay?
Okay.
As it relates to you, Mr. Page, are you requesting court-appointed counsel? Say it so that my record can
No,
pick it
Your
up.
Honor.
You are not. Are you seeking to represent yourself, sir?
No, I was gonna proceed with my attorney. Yeah.
And so
you're
the games
saying-
are continuing.
No, the problem is discovery, and where we want to proceed without seeing the discovery.
You want to proceed without discovery?
I guess that's the question is that the question you have for us?
I asked you, were you ready to proceed? And then I already know that you've not even requested discovery. So huge issue there. Huge issue. I got 4 defense counsels in the back seat. They're probably about to like puke in the back seat. You're about to proceed on a felony matter to which the maximum penalty is 2 years and or $2,000. And you're going to do it without seeing any discovery or requesting it for that matter. You're not even interested.
Okay, we're not ready to proceed. Like I say, all I can tell you, Judge, is the personal matter that I have been dealing with Mr. Page.
I understand that you probably have a lot on your hands as you are his mother. But you
Yes.
decided you're the one who has the law license. You're supposed to be the professional. You're supposed to be the trained intermediary. And you presented yourself before the court today, very late, without properly filing an appearance. This is the second time you've appeared on this file. You've not requested any discovery. You're back and forth as to what you may or may not be ready to proceed on. And then 1 minute you're telling me you are not gonna, doesn't want you to represent you. He has never told the court that. He's been very clear that you were representing him, and he's been consistent on that. You just were not here after already appearing and saying you wanted to continue to exam on today. So now you're not only wasting the court's time, but you're giving a runaround game. Then you tell me you want to proceed after I'm giving you an opportunity to explain that you're not prepared. You didn't do that. And so I have concerns about your professional responsibility at this time.
Like I will explain again. It was 20 minutes to 1 with the Zoom hearing when Jesse said, yes, I do want you to appear in that. Okay, I live in Hazlet.
I don't want to.
So I cannot.
I don't.
You know.
I
And
don't-
this morning also.
Sir, your preliminary examination was via Zoom, so you didn't have to drive here.
Probable cause.
Probable cause, I'm sorry, your probable cause was via Zoom. You didn't have to drive here for that, and you appeared via Zoom. So, but ma'am,
Okay.
so that's not the concern. I also don't know that if you're representing him or not, because at this point, the court's still very confused as to what's happening here. You shouldn't be disclosing to me your conversations with your client.
Okay. What I'm trying to tell you is to give you a picture of what I'm dealing with.
Yeah, sounds like you're in over your head. Sounds like you have no experience in representing legal criminal matters. You probably either want to retain him an attorney or talk to him about requesting court-appointed counsel. Is what it sounds like, but I'm not your attorney, so I can't advise you, okay? I'm gonna let you go off the record and have a private conversation with him, and then I want you back in here in 5 minutes, okay?
Ma'am?
back on the record in the matter of Jesse Page, and so you've had an opportunity to speak privately with your client, and how are you all going to proceed on this?
Well, Your Honor, I will withdraw from the case and he will need a court appointed attorney.
Are you requesting court-appointed counsel, sir?
Yes.
Okay, very good. I have not officially filed this appearance, nor have I signed it. I'm gonna give this back to you. And, sir, due to this ordeal, we're gonna find good cause to waive your 21-day timeline for your exam because you're not otherwise prepared to proceed today. And then we do have a representative from the public defender's office. He can do an intake with you today, and they can see if you can get court-appointed counsel, okay?
Okay. Mr. Nickel, I think he.
Yeah, unfortunately, that's not how it works.
Oh, okay.
Yeah, yeah.
Because he did.
And why are you, you don't want to prefer, I mean, Mr. Abbott's really great. Have you heard of him?
I think Scott talked to him before.
Oh, okay, I would say, but if by chance you got Abbott, you'd be fine too. Putting in a good word for you. Do you have any questions?
No, that would just be rain or.
No, you already had arraignment.
Oh, yeah.
So what we're gonna do now is we're gonna adjourn, which means we're gonna continue the date for this for another time. I'm gonna give you a new probable cause conference as well, because typically you would discuss at the probable cause conference any offers or any discovery, which you all don't have. And so that way you can have that with your new attorney. Then we can make sure you have a new attorney at that point, and then have a conversation with the prosecutor. And then we'll determine if you need to proceed to exam at that point. But I'm going to give you a new date for both the probable cause conference and the preliminary examination. The probable cause conference can be held via Zoom. You can come in person, but you do have the option of appearing via Zoom. You must appear in person for your preliminary examination, and your attorney must appear too, okay?
And the probable cause.
The attorney has to appear at all your court dates if they're representing you.
Yeah.
Okay, but you can come via Zoom for the probable cause conference. For your preliminary examination, which is what was scheduled for today, that has to be in person at the court, okay? And that will be stated on the paperwork we're about to get you with your next court date. Could I have a new PCC and PE, please?
PCC, May 13th at 8:30.
May 13th.
And then the exam would be May 20th at 9.
May 20th at 9. Okay, we'll get you a copy of those notices, sir. You're gonna go have an intake with Mr. Abbott. And you don't have any additional questions at this time?
I have to choose Mr. Abbott here?
No, he's not gonna be, we're not saying he's your attorney.
Okay.
We're
sorry.
saying he's gonna do the intake, meaning you
Intake,
have to
okay.
do a paperwork because contrary to what may have been the process when you were maybe a requested court appointed counsel before, those requests are now reviewed by the public defender's office.
Okay.
So they will review and make sure you're eligible to have representation by their office, okay? So
Understood.
he has to do the intake for that review, okay?
Understand.
So he'll sit with you and get some information from you privately to have that review done, okay? I'm not saying he's going to represent you. I was just suggesting if, when they assign, because I don't know how they do it, it could be random. When they assign, if you got him, you shouldn't be objecting and asking for nickel because they can both do a good job for you, okay? That's what I'm saying,
Yeah,
okay? Do you have any questions?
No, Your Honor.
Okay, any additional matters, counsel?
Only just to make sure it's clear for the record and the defendant, both of the officers are present today and the people prepared to proceed today, and it should bind over, even without the victim, under MCL 768.27 state. Your attorney will give you that statute number. They're familiar with it with my cases.
Okay, so you don't need to, that's what the attorney's for. You don't need to worry about that, okay, sir? Did you have any questions?
No, Your Honor.
Okay, and you're all set, and Mr.
Sorry
Abbott
for
is
the
right there
misunderstanding.
with the nice tie there. I think it's got some cars, Mr. Abbott.
Okay.
That's Mr. Abbott.
Thank you.
Thank
Sorry,
you.
Your Honor, for taking up your time with this, but
Well, you didn't just take up mine, you took up a couple of our public employees' time by these were games, ma'am, and I recognize your hands are full, but I think you're out of your league. You don't have the experience to handle this. You're putting yourself and your son at risk by doing what you did.
Like I said, I have recommended before that he gets a public defender. I
It's
did
more than just a
represent him in
recommendation.
matter
Your son
similar.
can't make you represent him. You're the professional.
Yes, that's true.
When did you retire from Department of Corrections?
I worked there from 2007 to 2017. And
Okay,
then I worked for Human Services for a while as an administrative law judge.
okay,
Yeah.
sounds good, sounds good. Okay, I was a former litigation manager at Department of Corrections. And at the AG's office, I handled Department of Corrections cases. So your name just didn't sound familiar. I was
No, it's been a while since.
handling, no, I would have been there when you were handling cases, but
Hmm.
nonetheless, I think you made the best choice by getting someone who does criminal defense to assist him.
And that's true. Ever since I retired, like I say, everybody I know wants my help and divorces and all this other stuff. So, you know, I've handled a lot of matters like that. My Secretary of State hearings and stuff like that. But, you know, criminal matters are not my everyday.
Oh, thank you.
Thank you very much and have a good day.
You too. Okay, we're on the record in the matters of the people of the state of Michigan versus Anthony Anderson in file number 22-00442 FY. Alexavier Church, file number 22-00445. Dalton Moore, file number 22-00447. And then Marion Dunwoody Moore, file number 22-00446. Council appearance.
Good morning, Your Honor. Andrea Lacy, appearing on behalf of the people.
Good morning, Your Honor. John Abbott representing Dalton Moore. He's present and seated to my right.
Your Honor, Eric Samal for Anthony Anderson, who's present.
May it please the court, David B. Carter Jr. on behalf of Mr. Church, who is present and sitting at council table.
Good morning, Your Honor. Ronald Berry. I represent Mr. Morian Dinwiddie Moore, who is present and seated to my right in the pew due to the accommodations of the court.
Thank you. And today was the day that was set for preliminary examination. And are we ready to proceed?
Yes, Your Honor.
We have any preliminary matters before we call our first witness?
None from the people.
Your Honor, I call you.
Yes. Yes.
Your Honor, after viewing the video, I'm concerned that Mr. Cowie will be incriminating himself today, Your Honor, if he testifies truthfully as to what he did and what he saw that day. And if the video of the event is presented to the court, I think that the court will see Mr. Cowie committing felonies. I'm concerned that he needs to be represented by counsel.
I likewise concur with the statement just made. If he testifies, he's going to need to be read some rights, and he testifies as expected, he will permit himself.
You said Mr. Cowie?
That's correct, Your Honor. That's referring to my victim in this matter.
Okay. Okay, so there's a concern that he may self-incriminate by proceeding without counsel.
That's my concern, Your Honor.
Okay, it's a valid concern. I'm not sure why the prosecution didn't secure or discuss that with them.
I have no concerns, Your Honor. My office does not intend to charge Mr. Cowie with the crime at this time.
That saying that you're not gonna attend at this time doesn't mean that after that information is out there, that they can't later just change their mind. Mr. Berry.
I was just gonna say, though we often get into these intention type arguments. If the people are indicating that they are offering immunity to the witness, that's not been provided to a copy of it to the defense counsel, or at least to myself.
Stacey?
That's correct, Your Honor. No offer of immunity has been made because my office is not going to charge Mr. Cowie with anything that was arising out of this incident.
Okay, I'll advise Mr. Cowie when he's called of his rights. And so, and ask him if he would like to have representation before he proceeds.
Thank you, Your Honor. Nothing further from me.
Okay, any additional matters from any of the other defense counsel?
No, Your Honor.
Okay, thank you. You can call your first witness. Oh,
I
sorry.
guess, I don't know how many witness sheets plan on calling, but I would ask for a sequester vote.
I will grant their request for witness sequestration. There are no witnesses present in the courtroom at this time, are there? I think there's only two other people that are here, other than.
Not that I
parties.
subpoenaed to be here.
Okay.
The two spectators will probably be called as witnesses at trial. Trial is where we end up.
Oh.
So I ask that they be removed from the courtroom at this time as well
Okay.
and be sequestered.
Okay, sequestration is ordered, so you all need to be removed as potential witnesses, okay? Is someone getting your witness?
I'm gonna go grab him.
Oh, okay.
Sorry.
No, I thought I saw an officer, somebody pulled out, so I wasn't sure. He was spraying that stuff before. And now I feel he needs them. That's why.
Judge, if I could just have a minute, my, Rick's actually on the phone with the attorney right now, and they want to talk to me real quick.
Okay, sounds good.
Thank you.
Drop the record. Cash on the record in the matters of Moore, Church, Anderson, and Moore. We went off the record so that the witness, who's I guess the alleged victim, can have a conversation with an attorney, correct?
Correct.
Okay, well, update, how are we proceeding?
I did speak to the attorney as well as the witness, and they, at this time, they both would prefer that I get the immunity paperwork secured, prior to the testimony. I know this is a huge inconvenience for the court and everyone else, unfortunately. I don't necessarily know that it's necessary, however, they would feel much better had they do that, and I think it's necessary, and this case requires Mr. Cowie's participation in order to go forward, so I think that at this time it's appropriate. And I'd ask for an adjournment, short adjournment, but adjournment.
Okay, I think based on the concerns indicated at least by two of the attorneys, and I joined in that concern. We don't want a witness testifying and waiving any of their constitutional rights, just based on a promise on the record. That's not gonna be security for the witness, and he has the right to be represented if something like that is gonna be at stake. So I'm assuming that there's going to be some immunity paperwork provided. Is that what you're saying?
Yeah, if the case gets adjourned today, I will work on it today. I will get it provided to that attorney and all the other attorneys as well as soon as I can get it together.
Okay, I don't, any objection?
No, you're, thank you.
Your Honor, in light of the circumstances, it's hard for me to object, but we are going to proceed today, and my clients here will want to go forward, but under the circumstances, I need to close this.
Thank you. I'm assuming
I
that's the
would place
position
an
of,
objection. We're ready to proceed.
okay.
I'd leave it to the court's discretion to determine whether it's good cause or not.
Yeah, I believe that there's the cause to grant the request for adjournment in an effort to protect the victim / witnesses' rights. All of the defendants are out of the custody of the jail. So no one will be sitting in jail waiting for their next court date. I don't see any immediate harm to an adjournment to our next available date, which we'll probably have to put on a probable cause conference so that we can make sure, or on a date that we normally do PCCs, to make sure we can address this matter. I do know someone has trial. Carter has a trial coming. You have a trial coming. Anybody else have trial?
July.
Oh, we won't. We won't be going that far out. We were thinking more like May.
My trial begins on May 20th is the jury date as of right now. So-
And yours is the week before, I think, Carter.
Yes, mine is, I have a trial on the 13th and then another one on the 23rd. I'm trying to
We
pull
just
up
one exam.
my June notices.
It's a continuation, and then what else? I don't think this is gonna be that long. So what do we got after this? Okay, we can put it at 9. Does the 5th work of May?
I'll be out of state, Your Honor, that first week of May.
Oh, okay, sounds good. Okay, so then we're not doing any of those. We may be going into June. That's the day before you fix the jury. The 19th is not good for you? Someone's picking a jury, right?
I'm
On the
sorry.
20th,
I'm sorry,
the 19th
of
of May, I'm sorry.
May.
Does that work for you?
That'd be fine.
Does that work for everyone? May 19th?
20 is better, but I can make 19th work.
Yeah, he's picking a jury
Oh,
on the 20th. So we'll do the 19th. At 9 a.m. Okay, any additional matters for the record?
No, thank you. Your Honor.
I'm sorry, is that a prelim then that day?
It's prelim, yep.
I thought I heard the court indicate that they were thinking about another PCC too.
No, what I was saying is that I have to put it on the day that we would do PCCs to make sure I have enough time to handle this matter.
All right, thank you. I apologize.
9:30,
I'll type
PCCs are done. We'll do 9:30 to make sure we finish the PCCs before. But Miss Lacy's gonna do a great job of making sure the PCCs are handled in advance via email, so that won't be a problem. So, no other matters, correct? Mr. Berry and Mr. Abbott, okay, all right, we'll get you all on notice for your next court date. We're off the record.
I apologize. I have one bond condition I could bring up.
Back on the record, who's your client?
Anderson.
In the matter of Anthony Anderson, there was an issue as to bond.
Your Honor, Mr. Anderson was residing with his grandmother at 217 Denver, same street that the victim lives on. He is a caregiver for his grandma. I have documentation from England County Health and Human Services that supports this. There's a bond condition, he can't be down the street, is that correct? And he would like to resume his caretaking duties of his grandma, who was in court a few minutes ago, was out in the lobby. And it's been kind of a burden on her. He was doing this since November 1st of 21. We'd like the bond conditions to be adjusted to allow Mr. Anderson to go to 217 Denver only to care for his grandmother.
And so the bond condition appears says he's has to be within 2,000 feet of the address of 317.
Which is probably within 2,000 feet.
Yes, it's about 5 or 6 houses down, so it would be within that zone.
Did you want to respond to the motion?
Your Honor, I would ask that it be continued at this time. I understand that this would cause a hardship to their family, but I think it's appropriate, given that my victims still reside at the same address and would like to be able to remain in their own home without any concerns of their own safety. And the city.
For what it's worth, Your Honor, my client never possessed a gun, had a gun under the incident. He's a 20-year-old kid.
Okay, and Mr. Emerson's on GPS as well?
Yes, ma'am.
Well, I'm going to amend the order to allow him to proceed with his caretaking duty. You said you do have something representing that?
Yes.
Thank you. And there's gonna be some strict compliance on that. Do you understand, sir? So you're not to have any conversation, communications. If this is 5 houses down, you're not to be within 5 houses of that house. I understand you're gonna probably have to pass that to get to your house, but it should be a pass to get to your house. You're being allowed, I'm only allowing this for the benefit of your grandmother, not for your benefit, okay? And so if there's any reason that the court has some concerns, it will go back to 2,000 feet. You understand that? You're not gonna let me down, are you? I didn't think so. I think I can trust you. Okay, any additional matters for the record?
We appreciate it. Thank you.
You're off the record.
What back would you want?
Oh, no, you can take that back.
Just in time.